Hearing the appeal, Four Seasons Holding Incorporated against Brownlie.
Yes, Mr.
May it please your ladyship and your lordships, I appear in this matter with my learned friend, Miss Mary-Louise Kinsler, QC, and Mr. Alistair Mackenzie, and we are for the appellant and the respondent to the cross appeal. My learned friend, Mr. John Ross, QC, and Mr. Matthew Chapman, QC, appear for the respondent and the cross appellant. Lady, the issues arise out of some facts in this case. I will, I hope, summarise the common ground as follows. By a telephone call made from the UK to Egypt, Lady Brownlie made a contract for an excursion with the concierge at the Four Seasons Hotel Cairo at Nile Plaza. The concierge was obviously acting as an agent for some other party. We would call it the hotel for the moment. In the course of the excursion, the vehicle in which Lady Brownlie and her husband, late husband, were travelling crashed and caused the death of Sir Ian Brownlie and personal injury to Lady Brownlie and indeed other casualties. We concede, for the purposes of today's arguments, that there is a serious issue to be tried as to whether the accident was the result of a breach of contract or a tort on the part of the hotel. In other words, we don't seek to say that it is nothing to do with the hotel at all, that liability has to be answered. It is also common ground that there is a three-stage test for establishing jurisdiction against a foreign defendant such as my client, a Canadian corporation. Firstly, there must be a good arguable case, as it's called, that the circumstances of each of the claimant's claims fall within one of the gateway requirements which are set out in the CPR at paragraph at CPR 6B, practice direction, paragraph 3.1. Secondly, that the merits of the claims are shown to establish a serious issue to be tried. And thirdly, that England is the appropriate forum for the hearing of the action. The live issues, which I will address in a different order from that in the written case, are as follows. Firstly, was the contract with the concierge, which was made by telephone between England and Egypt, was it made in England so as to satisfy the jurisdictional gateway under CPR 3.16a? That is to say, is there a good arguable case that that was where the contract was made? On that point, we say that the contract was not, or the good arguable case is not made out, and we also say that the judge on appeal, Mr. Justice Tugendhat, receiving the appeal from the decision of Master Cook, overstepped the appellate function in reversing Master Cook's conclusion, and therefore Master Cook's conclusion should be restored. The second...
On the ground that the point hadn't been taken? Or...
No, on the ground that Master Cook made an evaluation of whether there was a good arguable case that the contract was made in London, in other words, that acceptance was received in London. The learned judge said that that was a reasonable view to take, that people could take that view and people could take the other view, and he, the judge, took the other view and reversed the master on that ground.
They could both have a good arguable case, couldn't they?
Well, you can have a situation where the arguable cases match each other in, as it were, strength, because there's only a binary solution
Well,
to the question.
a case may be good and arguable,
But it's not.
notwithstanding that there are two possible answers to it. Indeed, it's normally a precondition that there should be two possible answers.
But it's not the better of the argument in the circumstances of this case, is what we say, because there is simply no evidence to deal with the crucial issue.
So it's a good arguable case, but not the better.
We say no, there was not even a good arguable case, because the crucial matter which has to be addressed is where is the acceptance received. And the claimant simply failed to address that question. It addressed the question whether a telephone call was made from England to Egypt, but simply the evidence simply failed to address who was the person who accepted the other's final counter-offer.
If there was no evidence to deal with the issue, as you've just said, how did it come about that the master cook made an evaluation that the contract was made in England?
Well, he made the evaluation that there was no good arguable case.
No,
He said Egypt.
no serious issue at all.
No, well, there wouldn't have to be a serious issue in relation to where the contract was made, because that is not relevant to the merits of the final determination. So that issue of an issue to be tried, it's not an issue that needs to be tried, where the contract is made.
Well, you can say there is no real issue on some point at all, or you can say there is an issue disclosed by the evidence, but the better side of the argument is on one side or the other. I mean, what do you say that Master Cook did?
Well, Master Cook looked at the evidence, listened to the arguments that were made, and accepted the argument that there was no good arguable case, that acceptance was received in Britain at the end of a telephone conversation.
He actually said, I think, paragraph 35, is that he expressed it in the same terms as you would express it if you were finding a fact, didn't he?
Well, I accept that but the way it was put to him, and it was argued in front of him, was on the basis of the Canada Trust and Stolzenberg gloss. All of that material was put before him, and he came to the conclusion that he did, which was a conclusion the learned judge said was a reasonable one for a reasonable person to come to.
For somebody coming fresh or fairly fresh to this area of the law, Mr. Palmer, it does seem quite extraordinary that jurisdiction in this regard should depend upon where the acceptance was received. And it might be helpful at some stage, convenient to yourself, if you were able to put forward other possibilities for how this question of where the contract was made might be decided in the future without reference to something so evanescent, esoteric, and hard to grapple with as receipt of acceptance.
Indeed, and we say that is part of the flexible, good arguable case test laid down in Canada Trust, that because it is so evanescent, that it is quite right, it should be extremely difficult to establish that something as evanescent as that has definitely occurred in one location rather than the other, because that is the only possible basis for suggesting there is a connection between the contracting party who is sought to be brought into the jurisdiction and the jurisdiction. And the whole basis of jurisdiction restrictions in the jurisdictional world is that there should be a substantial connecting factor between the defendant himself or his conduct and the cause of action which has arisen. And the only thing that can be suggested is this evanescent question whether the last word happened to be spoken by the concierge in the hotel,
But if there were,
or the last word by Lady Brownlie.
If there were irrefutable evidence that on the traditional offer and acceptance view, the last relevant word occurred in England, the connection with Egypt would be just as evanescent, but the answer would be plain, so that the vice that you criticise would exist anyway. The problem here is the obscurity of the evidence about where the last word was uttered.
Yes.
Is there any issue now as to the correctness of cases like Miles, Far Eastern Corporation and Dentoris?
No, they have been they have been endorsed, and there's a case called Brinkybon in the House of Lords, and there is in fact a recent decision about Mr. Bill Kenwright. Mr. Bill Kenwright, fortunately, had set out his offer in a document, and it was accepted by telephone by the other party who was out of the jurisdiction. And Mr. Kenwright had a diary in which he noted that his offer, which was, as it were, on the table, had been accepted, and therefore, because the acceptance was received orally in England, that was sufficient to show that the contract was made in England. So your lordship is quite right to say that if the evidence is clear enough, then this very evanescent circumstance is sufficient to get you through the gateway. Although,
So there's no point of law of general public importance involved in the question about where this contract was made, is there?
well,
Current law about where a contract which is made over the telephone is made is not in issue in this case. The only question is whether one side or the other has the better of the argument as to where the contract was made. And that, in a sense, is an evaluative question, isn't it?
it's an evaluative question. It does concern the application of the Canada Trust gloss, because we would say, following up Lord Wilson's prompt, I suppose, that where there is this evanescent and coincidental factor, it does, the trust case, the gloss in the trust case, does allow the court to take a flexible view as to whether the evidence has shown sufficiently a good arguable case.
And is the Canada Trust gloss in issue in this appeal?
Not as such. It's not a gloss which has actually ever been formally challenged in this House or the House of Lords, but its application is, I think, disputed to some extent in this case.
There's a bit of argument about the word much, isn't there, Mr.
There
Palmer?
is. Yes. There are a number.
Some people disapprove of much.
Much, yes. Well, I don't take a great exception to a disapproval of much, but it's what I want to get at is the rationale behind the gloss, and that it is that it should be directed at a number of different things. We'll come to it, but one of them is to establish that there is this good connection between the activity or the personality of the defendant, the cause of action which is created, and this jurisdiction, which there really isn't in this.
I mean, the problem about the law as formulated below, much of which was derived from the gloss, is that it appears at one and the same time to say that you've got to decide who has the better of the argument on the material available, and not to prejudice a subsequent finding at trial on that very question. I do not see how you can do the first without infringing the second.
Well, my Lord, I submit that conundrum can be overcome if one avoids trying to make a decision, which is what the Court of Appeal effectively did, about the answer on the facts, as it were, on the balance of probabilities, and one looks at it in a more flexible way to consider whether there is a jurisdictional connecting factor, and to look at the evidence in that way. What we say is the evidence simply didn't address the question. That's the problem. And then the Court of Appeal, quite wrongly, we respectfully submit, entered into a speculative reconstruction arising out of other terms in the contract which had been discussed in order to come to an impossible conclusion as to who had spoken last. And they were quite wrong to do that, as was Mr. Justice Tugendhat.
But I can see that some of the issues that you need to decide, that you need to, about which you need to come to some kind of conclusion on the jurisdiction issue, may be the same as are going to be an issue at trial. And you haven't got to it yet, but which company is an obvious example.
Yes.
But who had the last word? Oh, sorry, whose was the offer and whose was the acceptance in the telephone conversation? Is that
No.
even possibly a trial issue?
No.
So the danger there of, as it were, preempting a trial issue doesn't arise. Is that right?
Yes.
With the consequence that there would be no harm in hearing evidence about it?
Correct. I mean, there are situations in which the court can ask for the evidence to be heard and witness statements to or witnesses to be cross-examined on their statements. But we are discouraged very much by the courts, or the courts are discouraged from allowing...
By the Master's Corridor, no doubt.
Yes.
What are the rules about disclosure, Mr. Palmer, on that issue? If you get that kind of issue, which is a jurisdiction issue but is never going to be a trial issue, what are the obligations of the parties as to disclosure, if any?
Well, there are authorities which have endorsed and have allowed applications for disclosure.
Even though you haven't yet established that the defendant's
Yes.
properly before the court?
Yes, I must submit to myself, it seems a rather odd situation, but it has been done, and very...
You can order disclosure in a case where there's no problem about jurisdiction before action. Can you not?
I don't think you can in relation to a foreign
Sorry,
defendant.
yeah, but right.
But you can, yes.
You can
In a domestic context, you can do that, can't you?
I'm sorry, my lord.
In a domestic context, you can
Yes.
order disclosure.
Although it may be limited to personal injury cases.
Well, if you can, in principle, order disclosure pre-action in a domestic case, it would seem a little odd if you couldn't do so for the purpose of resolving an issue as to jurisdiction.
Well, it is a specific statutory power which entitles the court to order disclosure before action.
There is the difference, isn't there? The whole point about jurisdiction, or you would say, you at least say that one of the points about jurisdiction is that you don't bring a foreign party before the court unless you've established that you should. But if the rule is that you have to do your best, if you're the master, on the written evidence generally rather than oral evidence, why can't you at least require some kind of disclosure?
Well, my lord,
But suppose there were a document everybody knew would resolve the issue. It seems to me to be utterly absurd to say that the court can't have a power to order disclosure of the document.
well, my lord,
I'm not saying that's this case, but
it certainly, there are precedents for ordering disclosure. And
In relation to jurisdiction.
in relation to jurisdiction, there was one the other day in which it was contended that, I think it was Anglo-American South Africa Limited actually had its central seat in Europe, and they were ordered to produce, they said, no, our central seat is still in South Africa, and they were ordered to produce a lot of documentation.
Most of these cases don't hit the courts, but in my experience, it's not at all uncommon for disclosure to be ordered in relation to jurisdiction issues of
Yes.
fact.
Well, my lord, I would endorse that. My experience is not obviously as wide as your lordship's. I'm more in, I think, Lord Hughes's camp of seeing the slight intellectual difficulty. But I can confirm that it is commonly
But
done.
the problem about the intellectual difficulty is that you can bring a foreign party before the court for the purpose of determining whether he ought to be there any longer.
Well,
Yes. quite.
Yes, although it's
This is obviously of more interest in the next of the contractual issues
Yes, much more.
than it is in relation to...
yes. The point about the contract with the concierge and where it was made is that, first of all, it doesn't rely on and couldn't ever really realistically have relied upon any evidence from the defendant, because this had happened 3 years ago, and even finding who the concierge was would have probably been impossible. But so it's a self-contained issue in which the moral indignation which was expressed by Mr. Justice Tugendhat, and to a certain extent the Court of Appeal, does not and cannot arise. It is a simple, dry question of what the evidence shows. And we submit that Lady Brownlie and her advisors prepared evidence to show that they had made a phone call from Britain to Egypt, but did not address the question, which needed to be addressed in law, as to where the acceptance was received, with the result that the matter had to be argued on a sort of inferential and speculative basis. And we submit that indulging in that sort of speculation is contrary to the test that is required for a good arguable case.
I follow that. Was it entirely speculative? You're right, obviously, that they never thought, by the look of it, when they were drafting her statement and so on, about the question of whose was the offer and whose was the acceptance. Exactly. But is it right that she did say that what she was doing was not simply booking, as it were, off the peg what was on offer, but was suggesting a variation? Wanted the timings changed, well, and so on.
The problem is that the question of the price, which is one would have thought absolutely essential, and the last issue to be determined, is dealt with in a very confusing manner in the evidence. It sort of comes in a bit later on that the price was agreed at £1,000. And one would have thought that the natural thing is, well, I want to do this, and well, perhaps we won't make it this, and we'll do that, and can we have a few extra seats in the car? So, and then the hotel says, well, that's fine, and that will be $1,000, has to be paid in Egyptian pounds, apparently, $100 per person. And she said, well, that's absolutely fine. I mean, I'm speculating myself, but isn't that a perfectly ordinary way in which this conversation could go?
Well, one could imagine two completely ordinary conversations. Yeah. One with the last word being spoken in Egypt and the other with the last word being spoken in England.
I mean, my lady,
but
your ladyship...
It's not where the last word was spoken, it's where the last word was heard.
I know that, but in fact the issue of fact is going to be who said the last thing,
I mean,
and what they said.
The hypothetical reconstruction that you offered us half a minute ago would lead to your losing on this issue, because if they said it'll be $1,000 and we can do all these things, and she said, okay, that's fine, well, that would mean a contract made in Egypt.
Yes, so I'm safe.
You'd be winning on this issue now.
I mean, one's head does go round.
I mean, all of this.
Can we call them plaintiffs and defendants, or claimants and defendants, please, rather than appellants and respondents?
Yes, absolutely.
It's virtually impossible otherwise.
Well, certainly not, especially as there are cross appellants.
Exactly.
Yes. Lady Brownlie and the concierge were concentrating on. My ladyship says, your ladyship says, well, this isn't a matter of public importance, but I do have permission to appeal on it, and I put it before this House.
I was just seeking to identify what the issue was. We have now identified what the issue is. I think we thrashed it out as much as we can. Possibly we could move on to the next issue, which is...
Well, my lady, this was meant to be a mere introduction to all the issues.
I know,
I then had a few pages.
That's true, and you've been taken off your course.
But I
will... whetted our appetite.
So that was issues 1A and 1B are where the contract was concluded and whether the judge overstepped the appellate function.
Yeah.
The second issue was the contract with the concierge by some route of agency made with the defendant, the Four Seasons Holdings Incorporated, a Canadian company. The third issue is the issue in relation to tort and the tort gateway does the claimant's claim in tort for her personal injury and for her fatal accident claim, does the claim in tort satisfy the requirements of the jurisdictional gateway in CPR 3.19a, that damage was sustained in England? That arises both in relation to the claimant's personal injury and to her fatal claim. And we say that it doesn't satisfy that gateway for various reasons, which I will come to. And finally, we say, in relation to the fatal claim, that does not, in fact, pass the test of a serious issue to be tried, because the fatal claim is pleaded solely on the basis of the Fatal Accidents Act 1976. The Act does not have any application. See Cox and Ergo in this court, and it is not arguable in this case that English law applies to the fatal claim, being a claim arising out of an accident in Egypt.
Does it depend on the location of the accident or on the proper law of the tort?
The location of the accident gives you the proper law of the tort under Rome 2.
But the directly relevant factor is the proper law of the tort, is it? To the question of a serious issue to be tried, Well, to the question whether the Fatal Accidents Act has any application, does that depend on the proper law of the tort?
yes. And there is the Court of Appeal decided that English law did apply to the fatal claim because the Court of Appeal reasoned that when Sir Ian Brownlie was tragically killed, at that moment, the dependency, which was based in England, was lost, and therefore the place where the damage occurred was England for the purposes of the proper law of the tort, and therefore English law applied. Now that reasoning was rejected after the Court of Appeal's conclusion in a case called Lazar of the Court of Justice.
Well, perhaps we'll get to that in due course.
Yes.
If you won't start explaining what the answer is to your various issues,
No.
we get distracted.
Yes.
So,
I will just say to the court that try and work out what the outcomes are. If the contract was not made in England, then there cannot be any jurisdiction to try a contract claim against this defendant. If the defendant was not the other contracting party, then also there is no jurisdiction to try any contractual claim against the defendant. And also we would say the whole suggestion that the defendant is liable in tort must also fall away. If the damage is not sustained in England within the meaning of 3.19a, then there's no jurisdiction to try a claim in tort. And you will appreciate that the Court of Appeal decided that the personal injury claim was not, or the damage in that case was not sustained in England. That gives rise to the cross appeal, but that the Court of Appeal decided that the fatal claim, the damage did arise in England, and so they came to the contrary conclusion that the fatal claim, there was jurisdiction to try the fatal claim. And the issue, as I've said, of the serious issue to be tried on the fatal claim is only relevant to that fatal claim and not to any other part of the claimant's claims. Lady, may I come to the next section, which is just to describe the framework, and do it, I hope, quickly. The power of the English court to take jurisdiction over a foreign defendant is entirely statutory. We deal with that in our written case at paragraph 6, MS 106. We rely particularly on Waterhouse and Reed, Authorities, Volume 8, number 77, at MS 2947, at page 2951, and the Siskina, Lord Hailsham, at MS 2626. The present statutory authority is contained in CPR 6.36 and 6 BPD paragraph 3.1. That can be found in the authorities bundle, volume 9, number 88, at MS 3202. And the way in which the power should be exercised was described briefly by Lord Collins in a case called the Ultimo in 2012, and he put it as simply as this: on an application for permission, the claimant has to satisfy three requirements according to Second SAR. They are: first, the claimant must satisfy the court that in relation to the foreign defendant there is a serious issue to be tried on the merits, i.e. a substantial question of fact or law, or both. That's my last issue. The current practice in England is that this is the same test as for summary judgment, namely whether there is a real as opposed to a fanciful prospect of success. Second, the claim must satisfy the court that there is a good arguable case, that the claim falls within one or more classes of case in which permission to serve out may be given. In this context, good arguable case connotes that one side has a much better argument than the other. See Canada Trust and Stolzenberg, per Lord Justice Waller, affirmed in Bol's Distilleries. And thirdly, the claimant must satisfy the court that in all the circumstances the jurisdiction is clearly the appropriate forum for the trial. Well, that issue doesn't arise in this case because we didn't appeal against Mr. Justice Tugendhat's determination of that point. So predominantly, apart from the apart from a serious issue on the fatal claim in tort, this case predominantly concerns whether the claimant can pass through one of the gateways, and the test required, as you've heard, is that they should have much the better of the she should have much the better of the argument. We submit that the principles as to why the court should be cautious and should require this high standard of proof from the claimant is firstly to recognise that the gateway rules have been devised to ensure there is a sufficient link between the defendant and the jurisdiction, and or the activity or conduct of the defendant and the jurisdiction, to justify the courts in England in taking jurisdiction, to bring the defendant here and to try the claim against him. Secondly, to recognise that the decision on jurisdiction is, once taken, of final effect. Therefore, the decision is an important one. On the other hand, to recognise that the issue of jurisdiction is to be determined by a summary process, and that the decision on jurisdiction should be seen as separate from any judgment on the substantive merits of the case, and not usurping the power of whichever court tries the case to make a decision on the balance of probabilities on the merits when it comes to trial, if it does. And therefore, it must ensure, the court must ensure on a jurisdiction application that it doesn't carry out a mini-trial of the issue. And that applies equally to...
Is that to protect the claimant or the defendant?
It's a method of protecting both claimant and defendant, because if the court finds there's a good arguable case that, in this case, that the defendant is the contracting party, remains open to the defendant to defend the case on the merits on the basis that it's not the contracting party. Equally, the claimant, if he loses the point, is not, issue is stopped from relying on the same allegation in other proceedings, in other circumstances. So it protects both, but it also, we submit, ensures that the judge does not, that the court does not take jurisdiction lightly and insists on a high standard of proof that the court has jurisdiction to try the case eventually. Could I just take your lordships to the Canada Trust case? It's at the Authorities Bundle 2, Divider 19, MS 1085. And go, if I may, this was a case which the issue as to good arguable case concerned the domicile and the date of domicile of the main fraudster in a case brought by Canada Trust against him and many others. And it's where the Canada Trust gloss was, as it were, produced. And the passages of Lord Justice Waller start at 1091, MS page 1091, 553, letter B. The relevant standard of proof, the judge held that the convention defendant's application would fail if the plaintiffs had shown a good arguable case that the requirements of Article 6.1 as to domicile had been satisfied. He refused to accept the submission made on behalf of those defendants that the standard of proof required was what he described as the ordinary civil standard of proof, that is, on the balance of probabilities. We've had a full citation of authorities, and in particular, Second Sar and Far East, and the speech of Lord Gough is looked at. And if you go down to letter F, quoting looking at Lord Gough, there's the passage just under the letter F, B, second, says Lord Justice Waller, he, that is Lord Gough, demonstrates through his analysis that the House of Lords in Corner rejected the civil standard of proof in relation to establishing that the case fell within one of the relevant sub-paragraphs. And then he quotes Lord Gough extensively, and over the page, at the bottom of 1092, C, third, by necessary implication, Lord Gough must have rejected the notion of there being any different standard of proof, depending on whether or not a point will only arise at the jurisdiction stage. This point has now been affirmed in other cases. And then halfway between B and C, if it is important, I believe, important to recognise, as the language of their lordships in Corner's case demonstrated, that what the court is endeavouring to do is to find a concept not capable of very precise definition, which reflects that the plaintiff must properly satisfy the court that it is right for the court to take jurisdiction. And a little by letter D, the concept also reflects that the question before the court is one which should be decided on affidavits from both sides and without full discovery or cross-examination, and in relation to which, therefore, to apply the language of the civil burden of proof applicable to issues after full trial is inapposite. It's also important to remember, just under letter E, to remember that the phrase which reflects the concept good arguable case, as the other phrases in Corner's case, a strong argument and a case for strong argument, were originally employed in relation to points which related to jurisdiction, which might also be argued about at the trial. The court in such cases must be concerned not even to appear to express some concluded view as to the merits, e.g. whether the contract existed or not. It's also right to remember that the good arguable case test, although obviously applicable at the ex parte stage, becomes most significant at the inter partes stage, where two arguments are being weighed in the interlocutory context.
Well, there does seem to me to be an inconsistency here. If you are asking yourself which side has the better of the argument, you may not be expressing a concluded view, but the only respect in which you're falling short of a concluded view is that somebody else at trial, if it's relevant at trial, may form a different view on a larger body of evidence.
Yes,
Subject to that, you are forming a view on the evidence available.
you're evaluating some evidence which has not been tested in the way that evidence is tested when you have to come to a view on the balance of probability.
You're asking yourself who has the better of the argument.
Who has the better of the argument?
On the material, admittedly limited, that's available.
But we say that that is a different, wholly different in kind exercise from that of trying to decide on the balance of probabilities what the answer is.
But what is the difference between, if the difference is only what the material before you is, how different is the test? It's very elusive.
You're just deciding the balance of probabilities on a more limited basis of evidence, which you know will be superseded by a larger basis at trial.
Well, with respect, we say
than
that's
that.
what you shouldn't do.
Why?
What you should do is to make this evaluation of who has the better argument based on what material they put before you. And whereas one knows after a trial in which evidence has been heard, the court, the judge will say, well, I have to do the best I can to decide one way or the other between on the evidence which I've heard, which is not all consistent. But that is not, in my respectful submission, the approach that the court should take when applying the Canada Trust test and the Canada Trust law.
How do you actually do this? You've got a limited body of material. Surely, if you're going to say if you're going to decide who has the better of the argument, you've got to say, on this admittedly limited and maybe unsatisfactory body of evidence, it is more probable than not that X has the better of the argument. How otherwise can you do it?
Well, obviously one can say that the better of the argument is to be judged by whether you may not be certain, but you think probably he has the better of the argument. In fact, if the arguments are balanced, then the tie-break should go against the claimant, so that you're not obliged to do the best you can.
So you're saying it's a slightly stiffer test in a sense
It's a
for a
very
claimant.
different test. That's the
But it's very difficult to put your finger on it. If you're the judge and you think to yourself, well, now, what are the differences between these two tests? It strikes me as very, very tricky.
well. I accept that is a difficulty, and
This was entirely invented by Lord Justice Waller, wasn't it?
well, invented but then approved for however many years it's been since, 15 or so.
Well, I think I'm right. Has any, it has been approved by the House of Lords, but has any attention been directed to the answer to what you acknowledge to be a problem?
I think not.
No. So what is your submission about how this problem is to be resolved?
Well, my solution is to get away from thinking in terms of balance of probabilities and findings of fact entirely, and to look at the arguments on the material. And in this case, that is very straightforward because the material is so deficient that the arguments balance in a completely different way from normal. If the material is relevant and addresses the right points, then I would accept from Lord Sumption's view that you have to look at that material and decide which is better in balancing the two materials. But you're very much enjoined from carrying out any sort of exercise, which is to look at the evidence and decide on the balance of probabilities how it will turn out.
So, although you may in the end be doing much the same as somebody subsequent will have to do at trial, you shouldn't distract yourself by focusing on that.
Yes, my lord, I would submit that is
I
right.
suppose you have all the evidence which will be available at the trial. Suppose you have simply all the evidence that's ever going to be available. Is the test different or the same as it will be at the subsequent trial?
Well, if that is all the evidence that you have, then there will presumably...
I'm testing it on the basis it's all the evidence there's ever will have.
Yes.
That's quite often is the case.
Well, I would submit that in this case, probably all the evidence that we're ever going to have about where the contract was made, I mean, even if it were to be an issue in the trial, is available, because the answer is that, of course, Lady Brownlie can't remember precisely how the conversation ended. All she knows is that when she put the receiver down, she got a booking for a tour. And if that is all the evidence there is, then we submit that whatever your findings of fact are, you do not have an argument that a specific event occurred, namely that the man in the hotel said, "Yes, I accept your proposal, Lady Brownlie," that specific fact ever occurred. No one, if you know that you aren't going to get that evidence, then you know that one side has lost, because that argument is, as it were, frozen, is petrified, it's there. But if one side is saying, as here, oh, well, we haven't got the evidence here, but let's speculate as to how these sorts of conversations might have developed in order to come to the conclusion who had the last word, then it's quite wrong to adopt a line of reasoning which says, well, I think on the balance of probabilities, if I were to hear Lady Brownlie being cross-examined, I would come to the conclusion that X happened.
Looking at it as a question of principle, I understand your answer to Lord Clark's question to be that if it is clear that you have at the jurisdiction stage all the evidence that will ever be available at any stage, for example, you've got exchanges of telexes or emails, in that event, it is okay to decide it on the balance of probabilities. Have I correctly understood you?
Well, if you have all the evidence, it's difficult to see what issue you have to determine on the facts. If you have all the telexes, then what you've got to determine is a question of law as to which of those telexes amounted to the acceptance. That's what happened in Brinkybon, I think.
Right.
But it's difficult to see how you can decide something on the balance of probabilities on evidence which, I suppose your lordship is saying that the evidence is never to be cross-examined because for some reason everybody's overseas and therefore can't be brought to court or cross-examined on.
Let's suppose there's an issue of fact about which the relevant witnesses are dead. All right?
Yes.
What do you do then? Is the answer to Lord Clark's question that if you've got a situation where all the evidence that will ever be available is before the court, then you decide it in exactly the same way as you would at trial on the balance of probabilities? Is that the answer?
Well, I would respectfully submit that that is not the correct approach, that you should still deal with the question as to which side has the better of the argument, and much the better of the argument. And if you're in a, well, I really don't know because all these witnesses are dead, they're never going to be able to clarify the points which are relevant to the issue of jurisdiction, then you find that the claimant does not have the better of the argument on that evidence because those doubts remain and therefore their argument is deficient.
I think your gown is metaphorically being tugged.
Yes, but yes, I mean there is there is some authority that it is a tiebreaker, the test, in cases where you can't satisfactorily take the view that one side has the better argument.
But what is a tiebreaker?
The claimant fails, that they don't have much the better of the argument.
Well, that's just the operation of the burden of proof.
I'm sorry?
That's just the operation of the burden of proof, is it?
That is how the standard it operates in those circumstances. Lord Justice Waller also does refer to the test being having a degree of flexibility. We
discusses on page 558 the relationship between good arguable case and, for example, serious question to be tried.
Yes.
And
serious question to be tried.
There's a good arguable case is a threshold below the balance of probabilities. So you don't have to satisfy the balance of probabilities. So there it's on that part of his analysis. But how that fits on the better class of argument point, I don't know.
He gives an example, doesn't he, at the bottom of 1093. It's not this case, but it does give an example of a situation which must come up quite a lot at H. In a case concerned with contract where the jurisdiction depends on whether the breach was in the jurisdiction or not, but the trial issue is going to be whether there was a contract at all.
Yes.
And you must keep off the second.
Yes. But I respectfully submit that that is where he deals with the degree of flexibility.
Yeah.
And that may, to some extent, tie your hands, and does tie your hands, in indulging in the exercise of trying an issue on the balance of probabilities, because you're seeking to keep away from that sort of adjudication. And we submit that they are two separate forms of solution, finding a case on the balance of probabilities and establishing that one side has the better of the argument, and that there is this degree of flexibility which we would submit should be applied in a case such as this, where the ground for jurisdiction is this very, very short and very uncertain circumstance as to where an acceptance was voiced and received. And so we would submit that in this case, unless there is clear evidence that the acceptance was voiced by the concierge and received as the final acceptance by the claimant, that the claimant fails in establishing the connecting factor of the contract being made in this contract, in this country. Yes. And there are, I mean, there are plenty of cases where the judges are clearly keeping themselves to consideration of arguments rather than seeking to decide a case as to which is the more likely set of facts. Of course, a lot of these cases are massive fraud cases in which the most reprehensible conduct is being alleged by one side and denied by the other. And it's clearly in those circumstances impossible to go down the route of looking at a balance of probabilities on the facts. And one has to deal with it in this vaguer, but nevertheless, in my respectful submission, stringent methodology of
But we've already established that that problem doesn't arise in relation to this particular issue because it's never going to be an issue at trial. It won't be relevant at trial. And so the problem doesn't arise.
It doesn't arise in this case, but Lord Gough, as cited by Lord Justice Waller, said that the test should be the same regardless of whether the thing is going to arise later or not.
But the objection to actually hearing evidence and deciding it does not arise.
No. I mean, it would arise, for instance, in my Lord Hughes's example,
Yes.
where the question of a contract at all
Now,
was tied up.
obviously, it will arise in some circumstances and not in others. Is it worth spending any more time on this issue, as I suggested to you some time ago, because there are other
Yes, well, there
rather
are
more
pressing points.
tricky
I
issues,
don't.
and you're a third of your way through your time?
No, I know, and I'm concerned about that, my lady. Can I just, on the issue of where the contract was made, because it is clear on the evidence, I would like to ask your ladyship to look at the evidence. It's at MS 313. You take that away.
I wonder whether, when you refer to Appendix 1, you could refer to the internal numbers, because I started working from the MS numbers, but a lot of the pages were very, very faint. And I found that if I worked from a separate appendix, filed, I think, before the MS numbers were attributed, it was more legible.
I will try to do that, my lord, yes. As much
But isn't the evidence that of Lady Brownlie?
Yes.
Well, that's not at 313.
313 is the initial evidence,
No, that was a solicitor's.
and that's 146, yes. So that's the evidence that was put forward at the ex parte stage in front of the master to establish a good arguable case. What is interesting is that that is doesn't in fact refer to a cost of the tour being discussed at all, and it certainly doesn't refer in any way to the question that is in issue. And if we go to...
It's paragraph 7 anyway, is it?
It's paragraph 7, yes, and that is the only reference to where the contract was made. And it does appear, as I think my Lord Wilson said, or Lord Hughes said, that the claimant's advisors seem to consider that making the contract by a telephone call in this country was all that needed to be proved, and so the question was never addressed. And then at 394, or 435, if we go straight to Lady Brownlie, which is 268, she says almost exactly the same at paragraph 6, going over the page. And she describes how the tour was being described to her. And then at paragraph 8, she says, the cost of the safari was to be $1,000. This included the cost of the vehicle, the driver and the tour guide, and so on and so forth.
And your point is, she doesn't say whether that was told to her by the concierge on the telephone, in the telephone conversation, or later.
Well, one assumes that if there is a contract, the price must have been agreed for the tour that she was taking, and I've read that as, although slightly out of order, as being the discussion of the price.
Well, the price wasn't as I recall it, correct me if I'm wrong, referred to in the brochure.
No.
And therefore the price must have come from the Egyptian end.
Yes. And 394 at page 227 of the appendix is the solicitor's case that the claim in contract was made in England. At paragraph 21,
Which 227 is it?
it's MS 394 and 227 of the appendix. And what he says at letter C is the contract for the provision of the excursion was entered into by telephone from England and therefore within the jurisdiction.
So, written by somebody who hadn't read recently, Miles and whatever it is.
And Tories Far East, yes.
And so on.
Or perhaps they no longer do it in contract classes these days.
So we say, my lords, my lady, that evidence is wholly inadequate to make the better of the argument that the acceptance was voiced by the concierge, and indeed, if one goes down a balance of probabilities route, which one shouldn't, we would say that on balance, it is far more likely that the price was voiced from Egypt and was then accepted from England to Egypt. The Court of Appeal, we respectfully submit.
I mean, is it realistic to think that a concierge standing there would be able to take in all the bespoke requirements of Lady Brownlie down the telephone and there and then say, well, for that, the price will be such and such? Isn't it actually more likely that she would accept it was going to be a reasonable price, and the actual price was notified to her later, which is slightly the drift of her witness statement?
Yes. Well, if the, as I say, if the price was not agreed before she got to Egypt, or in some separate conversation which we haven't heard about it.
Well, you have to read paragraph 6 of her statement as well, don't you? Because, there are all kinds of theoretical possibilities as the moment at which a contract was concluded.
Yes.
There, that it appears to have been agreed, or so she said, that the cost was to be included within the price, which was to be charged to our room.
Yes.
So one possible view is that that's when the contract was made.
But the $1,000 label simply turned up later.
Yeah.
Well, the particulars of claim.
Because she says, following this telephone conversation, I was confident that the safari had been booked. As a result, it might be said that that's what she was told by the concierge. And it was that communication, it might be said, which concluded the contract, and is evidence, perhaps sufficient evidence, perhaps not sufficient evidence, that there was a good arguable case that the contract was made in England. Though there might be also a good arguable case that the contract was made in Cairo.
Yes.
Well, your submission, as I understand it, is that the evidence of Lady Brownlie is consistent with either possibility, if supplemented by appropriate speculations. That's your argument, isn't it?
Yes. If one is dissecting it in great detail, in paragraph 14 of the particulars of claim, which is at 366 MS 199,
That's the pleader's synthesis.
There's a nice element of Alice in Wonderland about all
my respect for submission is that this is a very short point, which on that evidence couldn't possibly establish a good arguable case to the proper standard.
Well, what's wrong with the argument I just put in, based upon paragraph 6? She regarded that as when the contract, the safari had been booked, it was on terms that a reasonable price would be charged to the bill.
Well, it's perfectly possible explanation. But
First way she puts it, and
there are
there's no-
several others.
Well,
The trouble is, she says that it was as a result of the telephone conversation and not of any particular thing that was said in the course of the telephone
Yes,
conversation.
she doesn't even break the negotiation down to offer an
you
acceptance.
could say that, but well, anyway.
Astonishing if she did, wouldn't it? It would be astonishing if she did.
It is rapidly becoming clear to me that we could spend the whole of your 3 hours
Yeah.
debating this short
Yes,
point.
My lady, you're quite right. Can I just make some points about the Court of Appeal without just in very brief terms, that at paragraph 69, the Court of Appeal equally adopts a balance of probabilities test and makes assumptions about who said what, which we submit is wrong under Canada Trust. And Lady Justice Arden also misunderstood Lord Wilberforce in Brinkeybon because she suggested that Lord Wilberforce in Brinkeybon, which in any event is many years before Second SAR and Canada Trust, was saying, well, you have to do the best you can to come to a conclusion on the evidence. In fact, he's not saying that. If you look at the authorities bundle 2, tab 16, MS 1042, at 1048, letter G, Lord Wilberforce is saying, in the case of successive telephone conversations, it may indeed be most artificial to ask where the contract was made, and if one asks the parties, they might say they did not know or care. The place of making a contract is usually irrelevant. Unfortunately, it remains in Order 11 as a test for purposes of jurisdiction, and the courts have to do their best with it. What Lord Wilberforce is saying, you have to do your best with the statutory rule, not that you have to spend hours poring over a piece of evidence which is never going to be tested in cross-examination or even elucidated and try and work out what is really meant. If the claimant doesn't say that the rule is satisfied because acceptance was received in her earpiece, we respectfully submit it cannot succeed. Can I then go on to the appellate function point?
But Lord Wilberforce was considering two different types of case. Was the contract made as a result of a telex communication or by some other method? So we don't get much out of that, do we?
No, it's just that the Court of Appeal thought that he was saying, oh, you have to do the best you can by analysing the evidence and coming to a conclusion on it, whereas he wasn't. He was just saying, you have to do the best you can with Order 11, which has this evanescent possibility of jurisdiction where there is a contract made by this single word being spoken.
Well, it might be thought that making your best of Order 11 in the context of something which is irrelevant to the main dispute but is most relevant to jurisdiction is having a proper hearing about that issue. You might think that was doing your best with it.
You might think that, but of course the courts discourage having that sort of...
Yes, well, we've had this debate. I really do think we've got to move on to something more interesting.
Yes, well, I'm afraid this may not be that much more interesting, but this is the question of the appellate function. And we rely upon the Assicurazioni case, and that is at bundle 1 of the authorities at tab 6, MS 825. No, it's not, I'm sorry.
Yes, it is.
6.
Yes.
And it's the very well-known passage which was later approved in Datec of Lord Justice Clark, where he deals with these conclusions, the sorts of conclusions, and at 16, some conclusions of facts are not conclusions of
16,
primary facts.
sorry, I'm not with you. Paragraph
Page
16.
28, paragraph 16.
I've got that. Yes, thank you.
Some conclusions are not conclusions of primary fact. They involve an assessment of a number of different factors which have to be weighed. This is sometimes called an evaluation. It's often a matter of degree upon which different judges can legitimately differ. Such cases may be closely analogous to the exercise of discretion, and appellate courts should approach them in the same way. And on the next page, below letter D, in the paragraph starting little b, citing Lord Justice Mance in Todd's case, whilst reminding ourselves that so far as the appeal raises issues of judgment on unchallenged primary findings and inferences, this court ought not to interfere unless it satisfied the judge's conclusion lay outside the bounds within which reasonable disagreement is possible. So we say that that was this sort of evaluation by Master Cook. It was a pretty simple one, but it was an evaluation. And Mr. Justice Tugendhat's response to that evaluation, we say, was quite wrong. And that is at MS 277, which is page 49 of the appendix, although that seems odd to me, but it's got a 49 in the middle, my lord. Sorry, 277 at 76.
When you now tell us that it was wrong for Mr. Justice Tugendhat to depart from Master Cook's judgment, are you talking about his judgment on the offer and acceptance point?
Yes, just on
or on
this-
the identity of the defendant point?
No, just on the offer and acceptance point.
Paragraph.
He deals with the law at paragraph 77 to 79, and then he recites the evidence at 81 of Mr. Donovan, and at 82 of Lady Brownlie. That's set out in full detail. And then at 85, he says, on the basis of this evidence, it's not straightforward to analyse the conversation in terms of offer and acceptance. We accept that, obviously. The brief details given in the brochure can't be an offer. It seems to me, at 87, the most probable analysis of the evidence is the following. The brochure amounts to an advertisement, or at most an invitation to treat. The claimant started by informing the concierge she was interested in a shortened version, stated the number and ages of the family, put forward a proposal as to the revised itinerary. I infer that the concierge did put forward one or more suggestions for a tailor-made itinerary which would enable the claimant's party to return, etc. I infer that the concierge probably mentioned matters not mentioned in the brochure, that there was a requirement for a police escort, that the cost was to be £1,000, and that was to include the cost of the vehicle. I infer that having been told the options available, the claimant then told the concierge that she wished to make a firm booking for one of the options. I take that to be the claimant's offer. I infer that the concierge accepted by saying yes. So,
Mr. Palmer, I wonder whether we could just very briefly look at what Master Cook did say on this question of offer and acceptance. If you've got,
yes,
I'm calling it 73, it's his paragraph 35, and it's the second sentence.
Sorry, Master Cook.
Yes, paragraph 35. You got the second sentence? I accept
Yes.
Miss Kinsler's submission. The contract between the claimant and the hotel was made in Egypt.
Yes.
When the clerk heard Lady Brownlie agree to the excursion on the terms he had proposed and explained. How could he make that finding?
Well, my lord, my submission on that is that if one looks at the whole, this was the point Lord Hughes made, I think, if one looks at Master Cook's judgment, he was advised and did accept that the test was good arguable case, much the better of the argument, and he accepted that the better argument was Miss Kinsler's submission.
He couldn't possibly have found that as a fact.
No.
Well, then, why are we wasting time on the appellate function?
Well, because, my lord, what he found was that it was not, the claimant did not have the better of the argument, and that Mr. Justice Tugendhat did not in any way criticise what the what the master had done. He said that at paragraph 89 of Mr. Justice Tugendhat's judgment, he cites the passage your Lordship has just cited at the top of page 51 of the appendix, page 280 of the MS. I accept Miss Kinsler's submission. And Mr. Justice Tugendhat said, I reach a different conclusion from his with some hesitation. This is an issue which will not arise at trial. I accept that a reasonable person could think it more likely that an offer was made by the concierge after hearing the requirements, and it is one or the other, and either party could be said to have a good arguable case.
Well, Master Cook's reasoning appears to have been that the only party who could have explained what was available by way of service to meet Lady Brownlie's requirements was the concierge in Egypt, and that Lady Brownlie must have said, well, I'll have that then. That seems to be the argument. It involves a certain amount of speculative inference, just as the opposite argument does, but it's an intelligible argument.
Yes, both arguments are intelligible. Mr. Justice Tugendhat says that both arguments are more or less equally valid, and that he comes to a different view. And that, in my respectful submission, is not open to him in his appellate function. And it's wrong in those circumstances to say that because both the appellate court and the court of first instance have the same materials, that you simply have a complete rehearing of that particular issue.
Could we please move on to the
Yes,
second issue?
my lady. The contract, who was the contract with? My lady, in relation to this, we accept that the concierge or the concierge team was acting on behalf of the hotel, that is to say the Four Seasons Hotel Cairo at Nile Plaza. There can't be any doubt about that. The doubt is to what is the corporate entity which represents that hotel. What legal entity is the Four Seasons Hotel Cairo at Nile Plaza, and who owns or operates it? Now, we say that to alight upon Four Seasons Holdings Incorporated as being the party who owns or operates this hotel is fanciful and clearly not, we would respectfully submit, satisfying the good arguable test. We submit that if you look at the evidence, there is no evidence that Lady Brownlie had ever heard of Four Seasons Holdings Incorporated. The claim form, which was verified by a statement of truth, which is at MS 305, which is 138, sues the Nova Park Cairo SAE, a limited liability company founded in Egypt, which has a trading address.
I'm not with you. What are you reading?
MS 305.
I see. Well, my 305 is, I'm in the middle of some completely different document in FLAB 17.
It's the right-hand page number.
Which flag of the...
It's in the appendix.
Yes.
It's page 138 of the internal numbering of the appendix. MS page 305 is the claim form.
It is.
Oh, I see. It's in the core volume. I'm sorry, my lord. Your lordship looking at the core volume or the appendix?
I'm looking at the appendix.
Oh, I'm sorry.
Appendix, it's flag 7.
Ah, right. I mean, a reference to flags, certainly from my point
Yes,
of
I'm
view.
afraid I've lost all
There are an
those.
awful lot of numbers, Mr. Palmer, but as it happens, I've got them both open. So it's flag 7.
So we're at page 138 of the appendix, I think.
Yeah.
And we're at 305, and one sees there the claim form in which Nova Park Cairo SAE, which is given as its trading address, the hotel, is sued as the second defendant. And what Lady Brownlie says about that is that in the second paragraph over the page at 140 or 307, she says the claimant and her late husband chose to book their holiday with an international hotel chain for reasons of quality, safety and security. The same considerations caused them to book their excursion directly with the hotel. At no material time were they given any indication that they were in fact dealing with any third party or an independently owned Egyptian business. Subsequent inquiries showed that the Four Seasons Hotel at Nile Plaza was in fact owned by the second defendant, which is an Egyptian company. So we have the evidence that at the time of the incident, the hotel was owned by the Egyptian company, and that at the time of issue of proceedings, it had a trading address at that hotel. And we submit that by far the more likely...
did your side put in any evidence on any of this?
We did put in evidence which was castigated by Mr. Justice Tugendhat, and our evidence is I've avoided really going to that because it's effectively been ruled to be inadmissible. But the evidence that was put in by Mr. Newman is at MS 385, which is
Tab 15, possibly.
tab 15. Yes, I think I'm now getting the tab numbering. And Mr. Newman put in the evidence, which is at 219, where he said the first defendant will contend as follows, that they are a British Columbia registered, they are a management company, they do not own either the Park Lane or the Cairo Hotel. There's another hotel in Park Lane. Both the Cairo Hotel and the Park Lane Hotel are owned by different owners. In the case of the Cairo Hotel, this is a company referred to, Nova Park Cairo SAE. The owners of the hotel enter into various agreements with a number of Four Seasons entities. These agreements will cover licensing, management and advisory issues. Four Seasons Holdings Inc. is not a party to any agreement in place with the Cairo Hotel. Now, Mr. Justice Tugendhat said that that evidence was worthless because it didn't give evidence of fact, that it didn't confirm the source of information, and it gave evidence as to the present day rather than the situation in 2010.
Well, it may be worthless, but it may be worth something. And presumably, Mr. Palmer, correct me if I'm wrong, the important bits are at B, to say that the first defendant is a management company.
Yes.
And the other important bit is at D, to indicate that the owner of the hotel was not necessarily, or indeed not, the operator of the hotel, because it enters into various agreements with a number of Four Seasons entities, depending on the jurisdiction.
Yes, but then he says that the Four Seasons Inc. is not a party to any agreement in place with the Cairo Hotel. So,
Four Seasons Holdings Inc. is not a party.
yes.
That's simply a reference to the company.
I'm sorry, my lord.
That's simply a reference to the particular Four Seasons company that they've chosen to sue.
Yes. So that is the point. They have...
But this is clearly not just a submission, which is how the judge described it, because these are statements of fact, and subject to the point about their relating to 2013 rather than 2010, they are not just submissions.
Well, I would certainly say that.
Yes, but the judge ruled them out partly because they're couched as submissions, and partly because if they're, to the extent that they're statements of fact, they don't state the source of the information.
Yes.
And what do you? I mean, they've gone, haven't they, to all intents and purposes?
Well, I've conducted the appeals on the basis that they have gone.
Except, I suppose, that they're at the very least flagged up an issue
Yes.
about the identity of the
Yes,
company which had made the contract.
Yes.
Mr. Palmer, are your instructions even today not to tell us who operates the Cairo Four Seasons Hotel?
I would consider it improper for me to seek now to put forward evidence about the operation of the hotel. I can certainly say that there was nothing deceptive in what was put forward in this evidence, and I wouldn't argue this case if this evidence in any way misrepresented the situation. But I'm not instructed to give this House precise details of how the Four Seasons Hotel chain of companies is organised so as to sprout, as it were, different...
Or indeed who the other party, therefore, to the contract was. I mean, your side is that what Mr. Justice Toon didn't care for, let's face it, was what he perceived to be a lot of ducking and weaving.
Yes.
And the ducking and weaving in particular is your complete failure to say who this contract was made with,
yes,
when it was made with some related entity.
Apart from the fact that it was made with the limousine company, which was absurd.
That was not a very good point.
And it is very unattractive to people like... It is very unattractive to judges who like to try and get somewhere near the bottom of at least some of the facts.
It's not as if your clients don't know the answer. They must know how their business is operated. They must know what the precise situation is in relation to each of their hotels. You might have thought that it was in their best interests, because those of us who've seen the evidence in this case and thought about this case might be tempted to think twice about staying in a Four Seasons hotel ever again.
Well, my lady, that is, yes.
Mr. Palmer, it would have been open to the judge, would it not, to say, given the rather obstructive attitude taken both in correspondence and in their evidence by the Four Seasons Hotel, there is no alternative but to direct an issue and to order disclosure at the expense of the Four Seasons Hotel in its entirety. That would have been a course open to the judge, would it not?
I would accept that could have been done.
And if we were to accept your submission that there is no evidence on the basis of which these defendants can have attributed to them this accident, that would be because of the reticence of your clients, and it would be open to us to make a corresponding order, would it not?
For disclosure?
For an issue to be determined, disclosure being ordered either by us or by the on remission to the trial judge entirely at the expense of your clients. That would be a course that would be open to us, would it not?
Well, it was a course which certainly was open to the claimants to ask for.
Yes.
When it issued proceedings. We are a long way down the line now. They didn't ask for that. They sought to establish jurisdiction on the evidence that they put forward. And it would be wrong in my respectful submission to, at this stage, to order that issue to rectify the situation.
These are discretionary points which one would have to assess before making such an order. But bearing in mind that the course of events, it might be that they would be discretionary points that would carry somewhat limited weight.
Discretionary points as to permitting jurisdiction?
No, discretionary points as to the procedural method of getting a satisfactory answer supported by evidence to an issue of fact in relation to which your clients are the only parties with the relevant information.
See, this is an issue, isn't it? This is an issue which, whatever
Yes.
happens here,
We-
is
we'll-
going to come up at trial.
I accept that.
And there might be a case, mightn't there, for saying that it ought to be resolved before we get into the difficult questions of quantum, if they arise.
And liability and...
Well, whether liability is an issue really or not, I'm not sure, but yes, both.
Well, my lord, I obviously have no instructions about that. There has been no application along those lines, but I can see the sense of your lordship's...
In that case, perhaps it would be helpful to us if you were to obtain such instructions in the course of the hearing.
Yes, my lord. I was going to take your lordships to Mr. McManus's evidence, but that perhaps doesn't... I'll just see if there's anything...
He says much the same as Mr. Newman, doesn't he?
It was. I think it didn't suffer the defect of putting forward.
He went a little bit further and did say that the defendants now sued neither own nor operate.
Where is he?
That is at 18, tab 18, MS 499 and 332 of the appendix is Mr. McManus. His evidence was also castigated by the judge for not having given sources of information. And he makes the statement following receipt of the claimant's evidence. He says he can confirm that the first defendants do not own either the Four Seasons Hotel at Nile Plaza or the one in Park Lane. That was a separate issue. First defendants do not operate either of the hotels, nor do they employ any of the staff working in those hotels or have any representatives based there. That was put forward as evidence which was material to the issues, and the master accepted that it was relevant to the period in 2010, and no doubt came part of his reasoning. But the learned judge rejected that approach and said this material was worthless and that all it did was to give evidence.
The trouble is that this is all part, it might be said, of what might be regarded as the kind of ducking and weaving we've been talking about. But what it's silent about is who the other party to the contract is on the defendant's case. I mean, your clients have simply been quite silent on that question throughout, haven't they?
Well, my lord,
I do see it puts you in a difficulty, and I do see that there are some difficulties about the kind of point that my lord was making a few minutes ago, but it's very, very frustrating.
Well, I do present this case on the basis that the jurisdiction or the power to bring Four Seasons Holdings Inc. before this court is dependent on statute, and that if the claimant doesn't know the identity of the correct defendant, then there is no, I respectfully submit, statutory remedy for that situation, which might arise in English law in domestic proceedings. But what this case, and I accept they had difficulties, although having said that, there were only, I think, 3 approaches to the Four Seasons lawyer in the 3 years or so between the accident and the issue of proceedings. But in the course of that period, that time, no one ever mentioned, there isn't a single document in here until the writ is issued, which mentions Four Seasons Holdings Incorporated. The claimants stated, or her advisor stated in various places, that the proper party to be sued was the Four Seasons Hotel Cairo at Nile Plaza, the Four Seasons Hotel Group, the Four Seasons Hotels and Resorts, and the Four Seasons Group. The only other company which appears in the documents is an entity called the Four Seasons Hotels Limited, which ran a website. So I do take the harsh position that if you want to bring a company into the jurisdiction, it does behove you to identify who that company is, and non-cooperation on the part of the defendant is not something which is remediable.
So your submission is that when an essential piece of information is available only to the defendant can effectively frustrate attempts to sue them by remaining stum.
Well, the proceedings were issued against Four Seasons Hotel, the Nova Park SAE that owned the building. It was stated that that Four Seasons entities have agreements with Four Seasons Hotels, so that it was indicated that there was that possible agreement between Nova Park SAE and a Four Seasons entity, but not Four Seasons Holdings Inc. And so that was perhaps a more fruitful line of inquiry for the claimant than simply to...
Those were the inquiries that they did in fact make in correspondence before that writ was issued.
Well, the only inquiry, the only Egyptian answer to an inquiry came from an Egyptian lawyer. I've not seen any correspondence, I don't think there was any, in which the Four Seasons Hotel itself answered any questions or were asked any questions by the claimant. So it was an unfortunate situation in which the position had not been really fully investigated before the issue of proceedings, which of course was quite late in the day. Lord, on this, we must get on if I may, but on this, my submission is that that it is, if you are satisfied that the corporation which has been sued is merely the owner of other companies which may be linked to Nova Park SAE, then what the claimant is attempting to do is effectively pierce the corporate veil by just saying the holding company has all the responsibilities for all the contracts which are entered into by other entities. And
how was the second defendant identified as a potential defendant? I mean, that party seems to have been identified as a potential defendant by the solicitors before they opened the correspondence. So how did they find out about them?
Well, I think Mr. Ross could probably answer that better than I don't know.
There's no evidence on that point, is that right?
I don't think there's any evidence as to that point.
I see.
Just that the claim form was issued against it. And that is where they obtained the evidence that it owned the hotel and had an address. I mean, maybe there was a Egyptian company search which was carried out. We simply don't know.
Which defendant were you?
Second defendant.
No,
Sorry, the first defendant.
I thought you meant the first defendant.
Did I say the second? In that case, I apologise. Obviously, at some stage, it looks immediately before the correspondence began, the solicitors decided that the Canadian company was a potential defendant. And my question was, is there evidence as to how they came to that conclusion?
No, I don't believe that they ever really did identify Four Seasons Holdings Incorporated as a defendant, but was merely the name that they, or was the entity which they selected as representing the Four Seasons group of companies. Because there's no mention of Four Seasons Holdings Incorporated until the issue of the writ, of the claim form.
Now, to whom did they address the first letter?
They addressed it to the legal advisor at the head office in Toronto, whose headed notepaper just simply says Four Seasons Hotels and Resorts.
Could we quickly look at that? It's at 182, isn't it, Mr. Palmer?
The correspondence with Mr. Donovan.
Ms. War's response.
Yes, 182 of 1.
Legal advisor. 182 in the Appendix 1.
Flag 9.
Could we find an MS number for that?
349,
Thank you.
yes,
Kingsley Napley, this is pretty promptly after the
yes.
terrible accident.
June
Is this
2000.
Kingsley
flag?
Napley had written a letter on the 7th of June, a chaser on the 23rd of July, and Ms. Wall responds,
Yes.
27th of July. We are in receipt of your letter. Mr. Palmer, when she says we, to whom does she refer?
Well, that I can't say, my lord. It was addressed to Four Seasons Hotels and Resorts Legal Department, and she replies as the corporate legal advisor of Four Seasons Hotels.
There's no corporate entity identified in this letter.
Correct.
Do you find that unusual?
Yes, I would certainly, in domestic law, I would say it was unusual.
Very well.
Yeah, there is an address at the bottom.
It doesn't identify.
It doesn't identify the company. No.
No.
Well, it's entirely consistent, the address, with the address to which the original letter, quite full letter before action was sent.
was sent.
Page 176, and therefore 6 pages before.
Thank you.
What she does say is that the AHD Limousine Company and
Yeah.
the Four Seasons Hotel Cairo have their respective insurance carriers, and that seems to be what she considers to be all that she needs to do, is to put the claimant in touch with the hotel and with the limousine company, which they say, Four Seasons Hotels and Resorts say, is the company that is responsible for the negligent driving, if it's established, of the driver.
Yes, it does also indicate that there is insurance carried by both,
Yes,
and therefore by the hotel.
yes. And then you see at page 190, 357, a year later, Mr. Donovan of Kingsley Napley says inquiries are ongoing, been in correspondence with the lawyers who wrote that rather unhelpful letter. We expect to issue proceedings in the High Court in the relatively near future. The Four Seasons Group will be named as defendants, and so on. And Four Seasons Hotels and Resorts, Marilyn Moore says, well, you should be directing your claim at AHD Limousine Company at page 192. And then there's one letter, rather remarkable, after the issue of proceedings at page 399, MS page 399 or 232 in the appendix, exhibit TD4, after the issue of proceedings, 3 months after, in fact, Kingsley Napley write at page 233, our investigation has continued. Proceedings have recently been issued in the High Court. The Four Seasons Group is named as the primary defendant. So there's a degree of confusion. One can see that even
There seems to be a certain amount of hopelessness on all sides, rather, I can see.
I'm sorry, my lord.
Well, I'm quite sure you can criticise the way that Kingsley Napley have been operating, because it's the idea that you could, in some vague way, simply join the group and Bob will be your uncle. It's a bit far-fetched, but...
Yes, well, that in respectful submission is what they've actually done. Now, I accept...
Well, it's not what they've actually done, but it is what they said they've done.
Yes, but that's what they're more or less doing, is saying, well, look, we wanted to sue every company there is in the group, but I submit that they can't do that. And to allow the claim to go ahead against Four Seasons Hotels Incorporated would indeed breach the corporate separateness of different companies in groups and would be quite wrong. And I cite, but I won't take your lordships to it now, Adams.
Your client's position was that initially that they should have sued the limousine company. You've abandoned that argument there now, have you?
Well, I say that they have a good arguable case. Well, not, they have there is a serious issue to be tried that whoever they contracted with to provide the tour is liable for the tour going wrong. There's no doubt that they could, if the driver was at fault.
I thought this was the point that you'd conceded.
Yes, so did I.
Yes, you have.
Yeah, I concede that.
I think you conceded it certainly before Mr. Justice Tugendhat. Was it conceded before Master Cook? I think it was, wasn't it?
Which
That
there is a good arguable case that.
No, the concession, as I understand it, was that the correct defendant was the proposition that the correct defendant was the limousine company was, to use your own words a few minutes ago, a bad point.
Well, it was not a point taken, but of course they are also.
It was a rotten point, wasn't it, Mr. Palmer?
Sorry?
It was a terrible point, wasn't it, Mr.
Certainly,
Palmer?
that it's a terrible point to suggest that they're the only person liable. I'm just saying that they would also be liable for negligent driving on the part of their
Be
driver.
liable in tort tax.
Yeah, but that's not what page 192 says.
192 of the appendix.
Yes, it does, or page 3.
Yes, no, I accept
mean, it doesn't
that was
say
bad.
they'd also be liable,
Yeah.
brackets, but we're liable too, or one of our associates are liable too.
Yeah.
It was not us gov, or nothing to do with us gov.
And of course, you know, in England, that would not be a bad point, because you'd say, well, sue the limousine company. They've got insurance which is unlimited, and
Yeah.
you know, it's your best target. But I accept that. So, my Lord, I refer to our written case, and the two authorities I wanted to refer your lordships to was Adams and Cape, which is at Authorities Bundle 1, Tab 3, and the VTB case. But I'm running out of time. The VTB case is at Authorities Bundle 8, tab
The keeping your
76.
powder dry point. Is it?
No, this is on corporate veil. In VTB, they wanted to amend to join the owner of the company. Held, you can't do that. The companies are separate entities, and if it's not Four Seasons Holdings Inc. that operates this hotel, then we respectfully submit that it cannot be joined as a defendant. Full stop. So now, have some order. Can I come to the points which are of public importance? My lady has been waiting.
Trying to get us there, but
Yes, I'm sorry, my lady.
no matter.
But we do have an appeal on all the points, and I appreciate that some are more interesting legally than others. Tort. The written case, paragraph 62 following, contain our response both to the cross appeal and our appeal at grounds 1 and 2. We also deal with the cross appeal in our responsive case, and our responsive case is at MS page 190. I don't know if it's in the, it won't be in the appendix as such. Our case is that the subparagraph in question, 3.19a, which requires damage to be sustained within the jurisdiction in a personal injury case, is not satisfied in circumstances where the initial injury to the claimant, and in a fatal case where the injury to the deceased is first inflicted outside the jurisdiction. That case succeeded in the Court of Appeal vis-à-vis personal injury, but failed in respect of the loss of dependency for fatal injury. The following is our line of reasoning. Before 1987, the court had no jurisdiction in a tort claim unless the tort was committed within the jurisdiction. And that can be seen in the relevant rules at tab 10 of authorities, number 124, page 3642. but I won't take your lordships to it. In 1987, there was a statutory instrument prepared to coincide with the coming into force of the Civil Jurisdiction and Judgments Act 1982, which also came into force in 1987. And in that statutory instrument, the rule was changed to its present form. So if I could take you to Authorities Bundle 10 at tab 125. We see here the 1988 White Book, which is the first one after the change, and your lordships will see the wording at F.
Well, I would like to have the MS number. If you would.
At MS 3646.
Thank you.
So, if the claim is founded on a tort and the damage was sustained or resulted from an act committed within the jurisdiction. And that is
Sorry, which subparagraph is it?
F,
F.
on 3646.
Yeah.
At 3670, sorry, 3670, you see the present form, which is tab 126. And that's at the equivalent of F is paragraph 9 at 3671. A claim is made in tort where damage was sustained or will be sustained, that's a separate, a new amendment, within the jurisdiction. So the wording has remained consistent and more or less the same since 1987. The note at 3652 to the 1988 White Book refers to the change in 1987 at the top, 11.119, para 1F. This subparagraph amends the law. Leave may be given if either the act causing damage was committed or if the damage was suffered within the jurisdiction, wherever the act was done. A similar rule prevails under Article 5.3 of the Convention, that's the Brussels Convention, as interpreted by the European Court of Justice in Bière and Mine de Potasse. The cases on the former 11H are unlikely to be helpful. That alteration was, as that note says, intended to bring what was then Rule 11H for non-EU countries into line with the jurisdictional rule laid down in Article 5.3.
Do we have Article 5.3?
Sorry?
Have we got the text of
Yes,
Article 5.3?
it will be here. Article 5.3 is in Volume 8, tab 89. No,
Try 9.
I'm sorry. Volume 9, tab 89. And it's MS 3214 at 3216.
Okay.
And that says in Article 5.3 that a party domiciled in a contracting state may, in another contracting state, be sued in matters relating to tort in the courts for the place where the harmful event occurred. Now, that very different wording, nevertheless, had been interpreted by the Court of Justice of Europe in a case called Bière de Potasse, Bière against Mine de Potasse. And we say that the European meaning of damage sustained indicates that direct damage must be sustained and not indirect or consequential damage in order to satisfy Article 5.3, and we say that that meaning is and has been attributed equally to the rule in the RSC and now the CPR. The next line in our reasoning is that in a personal injury case and in a fatal case, direct damage is the injury which occurs at the location of the accident, whether it be to the personally injured claimant or to the deceased, in respect of whose death a dependency claim is brought.
I mean, the jurisdiction rule assumes that the place where the relevant act occurred and the place where the damage was suffered may be different.
Yes.
So in what circumstances, I mean, is it your submission that they're necessarily the same in a personal injury case?
Yes.
And so in what circumstances, for example, would they not be the same?
Where as we'll see in commercial disputes, where a fraudulent misrepresentation is made in one country and the resultant damage occurs in another country, the immediate direct damage occurs in another country. The next line of our reasoning, or what I should tell you as an introduction, is that there was then a line of, there has been a line of personal injury and fatal cases decided at first instance, in which it was decided that the consequential suffering and financial loss suffered by a personally injured claimant on his return to the UK did constitute injury sustained in the jurisdiction for the purposes of BPD 3.19a. And that line of cases continued, as it were, feeding off each other. They were never considered by the Court of Appeal, and that continued until this case in Brownlie, which was the first case in which that line had been considered. And the Court of Appeal decided that those first instance decisions had made a wrong interpretation, and that the rule was that direct damage had to be suffered here, sustained here, which, as my Lord Sumption has said, it doesn't work, as it were, with personal injury damage.
Well, that wasn't an opinion I was expressing of my own.
No,
I was expressing my understanding that that was your submission.
Yes. Now, the position as to what the jurisdictional meaning of Article 5.3 is strengthened by the terms of Rome II, which is the Rome regulation, which may be found at Authorities Bundle 9, tab 93, at MS 3320, which is Rome II is the regulation which provides or stipulates what the applicable law should be in the case of a tort.
I mean, the main change here is that damages, whether analysed as procedure or substance, were henceforth to follow the proper law of the substantive act.
Yes. I mean, that was one of the effects. The other effect was that the universal rule as to what was the applicable law was to be governed by this regulation and not by domestic legislation. And that provides under Article 4.1, which I think is at 3320, that the law applicable to a non-contractual obligation arising out of a tort shall be the law of the country in which the damage occurs, irrespective of the country in which the event giving rise to the damage occurred, and irrespective of the country or countries in which indirect consequences of that event occur. So that it has been common ground that in a case of a car accident, the applicable law is the law under 4.1, if it applies, which it does as the default rule. The applicable law is the country where the accident occurs, where the immediate injury is inflicted upon the claimant. The Court of Appeal...
So that means, does it, that the choice of law is Egypt?
Yes.
So effectively,
In this case,
It's as simple as that.
as simple as that.
Yeah.
so the damage referred to in the penultimate line here actually means the injury.
Well, it obviously, again, applies to not just personal injury actions, but yes, the damage occurred is the injury.
I mean, if to take the example you gave minutes ago, you are on the receiving end of a fraudulent misrepresentation
Yes.
in England, and you then migrate to some other country where you end up losing money as a result. Your submission on that, in that fact, would be that the relevant place was England and the relevant law therefore English, notwithstanding that the claimant's bank account was subsequently transferred to Spain or wherever.
Well, that would certainly be right, assuming that there is an identifiable thing which can be called the damage which has occurred in England. One would normally assume that the loss from the bank account is the consequential event or the consequence of the event.
I suppose you are defrauded in England into buying a business in, say, Spain.
And so if someone rings you up in England and says, why don't you transfer some money from your Spanish
Why don't you
bank
buy this Spanish business from me?
Yes. Now, if you, and I don't know if there's an answer to this yet, but I would submit that if you transfer money from your London account to pay for that property, that your damage has occurred in London. But if you are persuaded to transfer your money in Spain to the fraudster, that your damage occurs in Spain. That would be a submission, but I don't think it's been decided in the context of applicable law in that sort of a case.
And what's its relevance here?
The relevance is that there is a sort of unified system between the jurisdictional dictates of Article 5.3 and the applicable law test for the purposes of Article 4.1, that both of them are looking to find where the direct damage occurs, and both of them do not accept that the place where indirect consequences occur is a relevant place, whether for jurisdiction or for applicable law.
You may be right that they both say that indirect consequential loss isn't good enough. One case to found jurisdiction and in the other case to produce the choice of law. But is it your submission that the place where the harmful event occurs, which is the jurisdictional question, is the same as the choice of law test in Article 4.1 of Rome?
It's not quite the same, but
Isn't, is it? Because
the same rationale.
I follow.
Put it that way. We'll have a look at beer, but
Yes.
under 5.3, the European Court said that the place of the harmful event can be either the place where you set off your pollution down the River Rhine, that's a place of the harmful event, so you can sue there. The place where the direct damage is inflicted, when it's downstream in the Netherlands, is also a place where the harmful event occurs, and you have the choice to sue in one or the other.
But from the point of view of choice of law, Article 4.1 seems fairly clearly to say it's the Netherlands.
You don't have the choice. You don't have the choice in 4.1. It would be Netherlands law.
Is this point discussed by Professor Briggs?
I'm not sure if we have Professor Briggs's view.
Well, you do have in Bundle 10 a number of pieces by Professor Briggs. I wondered if any of them dealt with this particular question.
Yes, is your Lordship referring to the sort of consistency between 5.3 and Rome 2, Article 4?
Well, the question of direct versus indirect damage and what constitutes damage, the relationship between the place of damage and the place where the harmful event occurred.
I think Professor Briggs does have a view on whether 319A should be interpreted consistently with 5.3, Article 5.3, which is generally that it shouldn't, and that there should be no real break on jurisdiction. But I'll try and get my learned junior to find
It's
something.
connected, isn't it, with the proposition that, which is advanced, I think, by Professor Briggs, but certainly if not in some of the first instance judgments that you mentioned, that one of the reasons why you don't need to read the English rule in the same way as 5.3 of the Brussels Convention is that there is, as it were, a sweep-up cure for problems in the forum convenience rule.
Yes.
Are you going to deal with that at some
Yes, I
stage?
will, yes. Now, the Court of Appeal took a wrong turn in deciding that whereas personal injury suffered could only be suffered at the place of the accident and therefore was not sustained within the jurisdiction.
So you say they're absolutely right to say all those first instance decisions were wrong.
Yes.
But they are wrong to carve out of that the fatal accident.
The fact that a fatal accident is different. And why we submit that the sort of marrying up of Rome 2 and 5.3 is important is because the Court of Appeal seemed to have taken the view that in a fatal claim, the damage is the economic loss which occurs at home, as it were, in England, even though the death occurs in Egypt. And the Court of Appeal took the view that therefore under 4.1, the applicable law would be English law because that's where the damage occurred. But that decision, or that line of reasoning, was disapproved after the Court of Appeal's judgment in a case called Lazar, which is in Authorities Bundle 10 at tab 101, which I will come back to if I may. Further, there is a case in Europe called Dumes, Authorities Bundle 9, tab 97, MS 3401, which also demonstrates that direct damage giving jurisdiction has to be damage to the direct victim and not damage suffered indirectly by a second victim because of the direct damage to the direct victim. So we say that the Court of Appeal was wrong not to to extend that reasoning in Dumes to the fatal situation. But as Lazar has more or less decided the point, we consider that the Court of Appeal was wrong to go down the route it did on Fatal Accidents Act. Now, The first point we wish to make is that what is lost sight of by Professor Briggs and the authorities that Lord Hughes was referring to, where it said, well, this is a wide jurisdiction if it's interpreted in the way that Lady Brownlie would like it interpreted, but it can be controlled by forum non-conveniens. That fails to take into account that by aligning this rule with Article 5.3 back in 1987, the rule was considerably widened, as your lordships and ladyship have seen. Before, you had to have the whole tort committed here. Now you can sue if the damage occurs here. And so that widening was intended to be, and should be interpreted to be, subject to the limits of Article 5.3 jurisprudence. And at the time that the rule was changed, the decision in Bière and Mine de Potasse had been decided and was there for everyone to see. And that is, as I said, I would like to look at it, if I may, Authorities Bundle 9, tab 95, at 3358. The case was, as you know, that pollution was sent down the Rhine from France and polluted seed beds in the Netherlands, and the question was whether the claimants could sue in the courts of the Netherlands or not. And I think I can just go straight to 3379, because this is the ruling that we submit was well in mind with those amending the statutory instrument in 1987. At paragraph 12 at the bottom of 3379, in matters of tort, 5.3 allows the plaintiff to bring his case before the courts for the place where the harmful event occurred. In the context of the convention, the meaning of that expression is unclear when the place of the event, which is at the origin of the damage, is situated in a state other than the one in which the place where the damage occurred is situated, as is the case with atmospheric or water pollution. The form of words, place where the harmful event occurred, used in the language versions leaves open the question whether it's necessary in determining jurisdiction to choose as the connecting factor the place of the event giving rise to the damage or the place where the damage occurred, or to accept that the plaintiff has an option between the one and the other. As regards this, it's well to point out that the place of the event giving rise to the damage is no less the place where the damage occurred. Sorry, no less than the place where the damage occurred.
They just simply said both places.
Yes, they do. And that's at 19. The meaning of the expression must be established in such a way as to acknowledge the plaintiff has an option to commence proceedings either at the place where the damage occurred or the place, the event giving rise to it. And 24 over the page at 3381. Thus, it should be answered that where the place of the happening of the event and the place where that event results in damage are not identical, the expression in Article 3 must be understood as being intended to cover both the place where the damage occurred and the place of the event giving rise to it. So one can see on that ruling that the bifurcation in the amended RSC rule matches this point, that you look either for where the tortious act was committed or where the damage is sustained. And then in Ruffer, which is at, which is Ruffer, it's the next bundle, volume 10, Well, perhaps I should take this more shortly. There was a case in Ruffer, 1980, where
Which
the
flag?
Dutch state...
Which flag in volume?
Sorry,
2?
it's flag 103. It's the MS number is 3473. The facts were that a boat sank in the Bight of Watum on the border of Germany and the Netherlands, and although the Dutch government had the responsibility of raising and disposing of the wreck, it seems that by convention the place where the wreck was technically within German territory. And if one goes to page 3476, 3476, 103. One sees at the bottom of the left-hand column, the state, that's the state of Netherlands, contended that the place where the harmful event occurred, within the meaning of Article 5.3, was not the place where the Otrati sank, but the place where the state suffered damage, consisting in the cost of removing the wreck, insofar as it couldn't be recovered, from the proceeds of sale of the wreck and of its cargo, and that place was either The Hague, where the state had its seat, or the Delfzijl, where it transpired that the proceeds of sale would be insufficient to cover the cost of removing the wreck. And ultimately the question didn't arise, but it was dealt with fully by the Advocate General at 3485. And over the page, he itemizes the question and says the question reflects the fourth contention. That contention is ill-founded. The state relied in support of it on the decision in Bière, but that authority does not justify...
Sorry, which page are you reading from?
3486 at the top. Can the place where the harmful event occurred be the place where the damage occurred, namely The Hague, where the state has its seat, or the Delfzijl, where the sale took place? The question reflects the fourth contention. That contention is, in my opinion, ill-founded. State relied in support of it on the Bière de Mine de Potasse case. That authority does not justify the contention. And the third, towards the middle of the page, he says, but the relevant damage in that case, that's Bière, was the harm to the plaintiff company's seed beds in the Netherlands caused by pollution. The place of the event was Alsace, where the defendant discharged saline. It was never suggested there, much less held by the court, that the place where the harmful event occurred could be the place where the plaintiff company had its seat, or the place where the amount of the damage was quantified, as was pointed out to us. If that argument was successful, then that would be tantamount to holding that under the convention a plaintiff in tort had the option of suing in the courts of his own domicile, which would be quite inconsistent with the scheme of Article 2. As for the suggestion that harmful event might be regarded as having occurred in the Delfzijl, I think it's enough to point out that the sale of the wreck by the Burgermeester was not a harmful event, but a means of mitigating the damage that the state had suffered. So significant limitations put on the question of where the harmful event occurs.
That appears to be the proposition which underlies the distinction between direct and indirect damage in Rome 2.
Rome 2 and in 5.3, yes.
Yes. It's an interesting illustration of how you distinguish between direct and indirect damage, but there must be some more general principle to enable one to do so on less arcane facts.
It's going back to Bière and Mine de Potasse, it's to do with establishing that there is a significant connecting factor between the elements of the tort and the location the place which is alleged to be the damage.
I mean, it's a slightly different issue, isn't it, in the context of you've got a corporate body or a state which can be said in one admittedly rather artificial sense to suffer the damage by way of a hit to its bottom line,
yes,
which might be said notionally to be a bottom line to be found in the place of its incorporation.
Yes.
That one can see as a wholly artificial concept. But if you've got somebody who normally lives in England and who, as a result of an accident in Egypt, requires, for example, extensive hospital treatment in England, it's not quite so artificial, is it?
Well, it is artificial in the sense that it is ignoring the necessity for a connecting factor between the tort and the damage sustained.
But the relevant connecting factor can be with the damage sustained alone.
Yes.
But once you accept that proposition,
But
then there isn't any reason, is there, why somebody who incurs medical expenses in England because they happen to live there and return there after the accident.
Well, it is inconsistent because, for two reasons. First of all, as stated here, it would mean that anybody could sue in their own domicile.
Well, in relation to certain kinds of damage, that naturally follows from the fact that the location of damage may identify the relevant law, irrespective of where the event causing it occurred. Once you've accepted that proposition, what is surprising about that?
It may do, but in the case of physical damage, there is a chain of causation which is physically connected to the place of the tort, as we saw in the case of pollution. And so, similarly, in the case of injury, it is physical injury which is suffered, and that, really by definition in a personal injury case, is occurring within limited distance of the occurrence of the tort.
So if you assume
Tortious activity.
that if you take a case where the entirety of the damage claimed consists of medical and rehabilitation expenses incurred as a result of a motor accident, is it your submission that the whole of that damage must be categorized as indirect for the purposes we're concerned with?
Yes, yes. Because in personal injury actions, I mean, even as a matter of English law, you have your complete cause of action at the moment that you are injured. There is then a question of quantifying the damages to which you're entitled, but you have already suffered damage once and for all when you are injured.
How does that work in a Fatal Accidents Act claim?
Well, that was more doubtful, because in a Fatal Accidents Act case, it can be said, well, the damage is suffered by reason of your loss of economic dependency. You don't have a...
And that's the sole basis of your claim, really, isn't it, in a Fatal
Yes, it
Accidents
is, yes. So my Lord Sumption's point would go better with a Fatal Accidents Act claim, but we say that under the European jurisdictional decisions, that it still counts as consequential, because you are suing, you're entitled, in consequence upon damage that has been caused to somebody else, namely...
Why do you say that the damage has been suffered in personal injury once and for all at the point of the accident? I can quite see the logic of that if you're talking about damage to an inanimate object, damage to one's property, one's car. It is because the measure is the reduction in value of the chattel as a result of the accident, and the amount it costs to repair it is simply evidence of that reduction in value.
Yes.
But that's not a logic that you can apply to a case where a human being has suffered injury, where in fact the primary measure of damages is the consequent need for treatment, care, and so on, all of which you say is actually indirect and therefore irrelevant.
Well, the need for for care arises at the moment of injury, but the payment for it occurs at some later date.
Well, that's not quite right, is it? Because the need for care arises throughout the period where care is necessary. If you return the next day to England, go straight into hospital and incur heavy costs in terms of medical expenses or loss of earnings and what have you, that is, in what sense can that represent a need that arises in Egypt?
Well, that is quite a long and difficult question to answer in English law, but there are cases where the actual incurring of expense or the actual incurring of loss of earnings is not linked in that way to the injury. For instance, there's a case called Baker and Willoughby where a claimant was injured so that he had a bad leg and suffered loss of earnings as a result of having a bad leg, and that was going to continue for a long into the future and had occurred in the past. But when he was then shot in an armed robbery and his leg had to be amputated entirely, the court nevertheless said that he's still entitled to the damage which accrued at the moment of injury when he got his bad leg. And although it's, as it were, theoretical damage from the time when his leg had been amputated, nevertheless he was entitled to recover it. So conceptually, there is a difference between a personal injury case and a case for pure economic loss. As I say, in the case of fatal claim, the pure economic loss is consequential upon direct damage which has been caused to the deceased by the tortious activity. And that is what has been decided in Lazar.
If you're going to have time, Mr. Palmer, and you may not, could you very briefly remind me, at least, because I've forgotten, what in practice is usually the relationship between the claim on behalf of the estate for the injury to the deceased, including, as I understand it, lost earnings in the lost years?
No, not so now.
Not so now.
Fatal accident, your lordship's going back to the...
Going back too far, am I?
Pure double recovery. And then I think in 1983, they passed an act saying you can't have lost years if you're dead.
Set off the one again. Oh, right.
You just simply don't have that cause of action anymore for continuing persons.
It's simply gone, has it?
Yeah.
So you don't have the problem of an overlap between those and the Fatal Accident Act damages. Thank you.
Lord, the next case I wanted to go to was the first decision that was given by the Court of Appeal after this change, which is called Mattal and Rostov. It's in the Authorities Bundle 5 at, I'm not sure the tab number, page 2077. But it may be that I can just...
If you only want to say a few words about this...
I'm afraid I don't. I need to say quite a lot about it.
You need to say quite a lot about it.
It's an important case.
Well, would you prefer to do so after the short adjournment?
Yes, I think that would be appropriate. For my Lord Sumption, I have the references in Briggs, which are in 10/108, which is a commentary on Brownlie at 3527, and 10/110 at 3547 to 8.
Thank you.
I think you gave us the wrong page reference to the Mattal case.
To Mattal 2077.
Hold on. Yes, it
Does
does.
that work?
Yes, it does. Right, it's all waiting for you at 2:00.
Yes, very well, my lady.
We look forward to hearing from you further then. We'll now adjourn.